Welcome to BDO's Legal Tech Talk podcast. We're joined by judges and legal professionals to discuss emerging trends, regulatory updates, and the latest headlines. We'll provide tips to help your law firms and legal departments make the most out of legal technology. I'm Daniel Gold, BDO Principal and eDiscovery Managed Services Leader.
And I'm Eric Dirk, BDO's Managing Director of Legal Operations. Let's get started with this episode's exciting discussion.
And welcome back to another episode of BDO's Legal Tech Talk podcast. And I'm very excited because today, joining us in the virtual recording studio is Carrie Sheehan. She is Taft Law Firm's Assistant General Counsel. And I'm excited for a number of reasons, mainly because I found somebody to bring onto the show who is as passionate about ethics and the law as I am. And she's probably actually more passionate than I am about this because this is what she does. She advises firm attorneys with respect to ethics compliance, risk prevention, conflicts of interest. She's got over 15 years worth of legal experience in civil litigation, conflicts of interest, and professional responsibility. And if that is not enough, one of the other things that Carrie does is she's an adjunct professor at the IU Robert H. McKinney School, where she teaches professional responsibility. Right there it is again. She's also a former assistant clinical professor of business law and ethics at the Kelley School of Business. In addition to all of this passion that she's got for promoting ethical compliance in the law, she is an avid speaker, given way over 200 seminars on ethics and professionalism for various local and national platforms. I don't know if I've missed anything here, but Carrie, welcome to the program. We are so glad that you are here to join us today.
Thank you. I'm excited to be here too.
Well, awesome. So you've got I must have said ethics maybe 5 or 6 times in the introduction of everything that you do. I'm going to start off, Counselor, with a compound question, if that's all right. And I'm very curious about not just what drew you to the legal profession, but more to the point, I'm very curious about why is it that you are so passionate about ethics? Like, what drew you to this particular part that you said, you know what, this is where my calling is?
Well, I'll start with the first part of your question. I've always wanted to be a lawyer. I remember even way back in elementary school telling my mother that I either wanted to be a lawyer or a taxi cab driver. She kind of geared me toward that lawyer path, probably rightfully so. In my defense, we just come back from a trip to New York where I'd driven in a taxi cab for the first time, and I thought it was fascinating. But yes, it was that passion towards the law. And so everything I did, even leading up to college and law school, was geared towards going to law school. And I don't know what drew me towards it. Maybe it was just watching old law movies at my grandmother's house or what, but I just knew that I was going to be a lawyer someday. But the ethics part of it didn't even come in till later. If you would have asked me in law school what I wanted to do, I would have said criminal defense, hands down. And guess what? I've never practiced one day of criminal defense, probably rightfully so, but I have never done that path. And it wasn't until probably about 7-8 years into my practice, about 2016, I was doing litigation. I was a plaintiff's litigator, doing, the daily grind, the depositions, the hearings, the trials. And finally, I just needed a change. And I was getting married. I just wanted to change out of the 24/7. I saw a random posting for a professional responsibility attorney in our local journal, and I just applied. I said, you know what? I'm throwing my name in the hat. We're just going to do it. Lo and behold, I got the job. I accepted the job. And then I called the person who was supposed to be my mentor or was my mentor when I did join. And I asked her, I go, what do you do every day? I had just accepted a job. I had no idea what we were going to do every day as professional responsibility counsel. And she looked at me and she just said, we will teach you everything you need to know. And they did. The law firm did. And then I just loved it. I loved the compliance piece. I loved it being like a puzzle. You were kind of being like a mediator and making decisions and helping get business into the firm, making sure there was compliance. And yes, we're called the no police a lot. Yes, we are, not the biggest fans of the event. When they see professional responsibilities or internal ethics counsel show up to an event, they're like, oh, now we have to behave. And so, we are not the most popular people. But I just enjoyed, the nuances of it, taking the rules, applying them, because the rules are so vague. It's kind of like that puzzle piece of how do we fit into different things. And since I dove headfirst into it, I started speaking on it. I started teaching at the Butler University as an adjunct back then in their Lacey School of Business at the time, and then transferred over to adjunct teaching at IU and the Robert H. McKinney School, as you said. So it was just, I fully immersed myself and I just enjoyed it. And so it's kind of like every lawyer, we always say what we want to do, but that never tends to be what happens in our path as being a lawyer. And we can always transition. And I don't know why the firm hired me back then with who knows what they saw on my resume, but they did. And it was just kind of, I found my path and my passion that way for it. Back then, it really wasn't technology. I mean, that was 2016. It was not even, Gen AI was not even on the mindset of anyone. I think more what it was there was someone in my office, or I'd heard a story. I can't remember if they're in my office or colleagues. And it was just kind of the worst point in their career. Like they had a disciplinary complaint against them. There was something going on. And we were the ones going to help. And I like that aspect of it. I think it gave me that trial part back that I wanted to get, out of the 24/7, but also still helping other lawyers stay ethical and compliant. And here in Indiana, we do have a judges and lawyers assistance program where if lawyers do get in trouble, we can work with them to help get them rehabilitation or services they need. And so having that too, coupled with just helping lawyers in general and being involved in both, it just kind of ignited something and I just enjoyed it. I enjoyed helping law, like lawyers and legal services. Laypersons are okay, but lawyers just kind of more than my bread and butter at that point. Yeah.
So here's what I'm wondering. So, at a lot of law firms, I don't often see that there is such a laser focus on somebody who's directly responsible for ethics, right? Or somebody who's directly responsible for ensuring that each of the lawyers uphold and maintain the rules of professional responsibility. So I love the fact that Taft does this. And I'm so curious. So how do you do that on a day-to-day basis, right? Are you, issuing memoranda out to everybody? Is everybody come to you before that they do something that they think is wrong? What does that look like?
Hopefully it's the latter. We try to stop fires and not try to put them out, afterwards. It more looks like, we get random calls. Like in any given day, maybe it's quiet that day, knock on wood, I'm not jinxing myself today. But people can call in or email either general counsel or myself with questions. And this can be anything. Did they have a grievance filed against them? A motion for sanctions, a motion for disqualification? Is opposing counsel threatening an ethical violation, or is there some ethics component in there that touches the rules of professional conduct? And so they call us, and then we counsel them on what to do in that respect. In addition to that, internally within Taft, I push out 6 CLEs, I think it's 5 or 6 CLEs a year on ethics topics for internally in the firm on different topics that our lawyers want to hear. We're also available to talk to different departments in the firm if they want to invite us to their departmental meetings. And then we do to monitor ABA opinions that come down, our different jurisdictions opinions that come down. I'm part of our AI task force and compliance group within the firm too, which is where the technology comes in as well. And so we test, demo, and figure out, do we need a policy on this? Do we not? What do our lawyers want? Like a lot of lawyers are wanting to use Gen AI. They're wanting to do those things. And so then someone needs to figure out, okay, how do we do it? And how do we do it ethically? So I'm part of that task force that works with IT and our client compliance group to make sure we can roll these things out and that we get the technology that keeps our lawyers ahead of the game and is efficient for our clients. It's kind of eye-opening to see what they think is okay and not. I've taught professional responsibility. I've taught other courses over at the law school as well. And I always call it, when I walk into a classroom, you can just smell hope. I don't know if that sounds weird or not, or it's just that they're still unjaded, unbiased. And so they have this innocence about them. And talking to them about different ethics, different compliance things, you kind of see it through the lens that maybe we used to be in our 20s or whenever we became a lawyer. And so they've kind of like reshaped my thinking to not be so callous, not be so certain things and how I kind of deploy my advice too. But they also kind of bring up new stuff. Like I've had students who have written notes on Gen AI in different areas. And I learned as much as that student did, him doing the research, me just reading the research, from his paper. And so they teach me too of what they're seeing every day and what's affecting them as students, and then their experience as law clerks and interns and that, because a lot of times once we get so far up in a firm, we don't get that, innocent experience or that experience they're getting. And a lot of their concerns come with, is Gen AI going to replace the law clerk? Is it going to replace the new associate? Especially when we're putting AI into our research programs and different things like that. So they're worried about those things. But then from the ethics standpoint too, they want to use those things, but they know they can't use those things. And then if you tell them they can't, they're like, why? And so then you obviously have to explain different versions of why they can't do certain things. And I first saw it when they started turning in papers to me at one point. This was when I was at the Kelley School. And I was like, this student wrote this a little bit too good. I know this student's writing. It is a little bit too good for this caliber. And so then I started putting in my syllabus, you can use AI, but you have to turn it in and different things. And then they want to know why. And so then we explain the ethics, and then it's like that light bulb goes off in their head about it. So I will say just seeing that innocence, seeing that, oh, this is all new and exciting compared to when I lecture to more seasoned attorneys is kind of a delight. Like I enjoy it. And so, yeah.
This is going to be another compound question for sure, Carrie. So I'm so interested in this idea of like the innocence of the students. So once a year, as I've talked about before on the show, once a year I get the privilege of going to be a guest professor over at the KU Law School, the University of Kansas. And it's so funny because I've been doing it for 5 years now. And I said to the students that I am most excited for them when they graduate, because your generation of lawyers are at this inflection point of the law, because they're going out there and they're going to have these tools at their fingertips. And we didn't have that. We had books, right? And so, and it is going to make a difference. And because it's so natural to them, then they get hit with, as you said, they go to the law firm, they get hit with, well, no, hold on a second, you can't use it, right? And so it's almost like there's this excitement coming out of law school as a 3L that, yes, I can use this. But then it's, whoa, who do you think you are, right? You're not going to do that at all. And I'm really interested in your perspective on, that's not congruent whatsoever, right? And so we want to be encouraging innovation in the practice of law. We want to be encouraging technology. But as you said before, you come across as the no police, right? Sometimes, by some people.
Sometimes, yeah.
So how do you fix that, at odds nature of law student excited, we have the tools, law firm right out of the gates, like, no.
A lot of it is education and kind of opening your mind. Like we can't be the no police, even though we're perceived as that, we can't be that a lot of times. So it's like, okay, you want to use this? Well, maybe you can't use this version. Well, let's figure out if the firm will purchase a closed circuit version or something where we can use safely. And then obviously you have to take it up, get the approvals, get the funding, money for it through the firm. But it's just kind of being open to those things because, Taft is modeled as the modern law firm. We want to stay on the forefront of the technology. We want to stay where, we're giving our clients the latest innovation. So a lot of times when younger lawyers come in and they have these ideas, we say, okay, we understand, maybe don't use that just yet, but help educate us on maybe what we can do on the back end. So kind of having that collaboration, and then two, talking to more seasoned lawyers saying, I know you've always done it this way. I know this is routine, but here is kind of the newest, latest, greatest thing. And a lot of lawyers are open to that because one, if you show them how it makes them more efficient, tell them that it's safe to use because we've done the research, we've read the terms and conditions, we've, done all that stuff to make sure we're compliant with the rules. Then they're more apt to start learning it, especially if it's going to make their life easier and is going to help the clients as well. So it's just kind of having that education and having the conversations. And I always say there's so much power in just picking up the phone and talking to someone and not sending an email. Like I can't tell you how many times an email's gone across and it causes a huge fight, but then you pick up the phone and it's resolved in like a minute because, you just don't get the same effect. So it's having the meetings, getting the education out to the firm, bringing those together and listening, actively listening. And that's what we try to do at Taft is actively listen. And if our attorneys want something, we try to figure out how can we make this possible if we can to help them and our clients with that. We have some purchased closed circuit safe versions within Taft that we're demoing right now that we're testing out. So I love to do those. Like I'll just put little things in there and say, rewrite this for me or do this. And sometimes it's pertinent to what I'm doing. Sometimes I'm just having fun with it to see what it can do. I have to say one of my favorites right now are the note-taking devices, the AI note-taking that can come across through different platforms, either like your traditional ones, or, you can get third-party ones too that, you can add into kind of when you do your Zoom calls. And I demoed one once and it was other people in the firm on it. So it was a very controlled demo. It was a free demo. We're on there, we're having a conversation. And so then I get back the transcript, I get the video that comes with the AI note taking. Then I see this little tab and I click on the little tab and I click on it and it was reading our facial expressions. It was reading our body language. And it said, Carrie was biased towards this speaker at this point. I was like, oh dear, this is not going to be pretty. Or so-and-so was disinterested, or so-and-so was not actively listening or looking away. I was like, this is going to be horrible. And this is a third-party note-taking one, not your traditional platforms where we do our calls, but a third-party one. And I just remember sending that to the people who were on the call and they're just like dying. They're like, oh my gosh, what if clients use this? And so understanding and demoing and playing with them, I think is half my job. If I'm going to be advising on them, I need to know how they function and how they work so that if our attorneys come to us or our group and say, hey, what is this? Obviously, IT is going to chime in and our client innovation services. But then if they ask me about the ethics, I need to know how does this operate and, what we can and can't do. And how is that really going to hurt us in the background potentially at that point? So
that is so wild. I had a non-Gen AI version of that once. I had a colleague on a video call with me who IM'd me and told me, stop slouching. It looks like you're not paying attention. So I had that also. Yeah. So the semantic analysis of nonverbal body behavior, that is so powerful because one of the things that just triggered for me is that with Gen AI, one of the things that I have heard other guests talk about, we found it ourselves, it helps elevate our ability to ask better questions. And the more that I've played with it, one of the things that we're finding is that Gen AI is really good at asking follow-up questions. Yes. And that kind of trains you. And the other thing that's really good at is if you're not asking really good questions, you're going to get really bad answers. And so now this takes it a whole nother level. This nonverbal body behavior and learning from that as well, that trains humans as well. I do have to ask, so did Taft buy this software?
Not yet. We are still demoing, looking into that note-taking one right now.
That is so interesting. What have you found to be the most interesting use cases that can help propel lawyers to not just do their jobs more effectively, more efficiently, but also drive better client satisfaction?
Sure. Some uses that lawyers can do or use cases. I found it most beneficial, and this may be for your smaller mid-sized firms too. It can help with your advertising. It can help with client FAQs. I know one lawyer was giving a local presentation to more mid-sized, smaller firms in the area. One lawyer said that he used it to create FAQs for the clients because he was a litigator. He also did some criminal defense work, and he seemed to keep getting the same repeated questions over and over again. So what he did was just take a ChatGPT or Perplexity or, another third-party AI, public one that's available, and just say, make me FAQs for this. And there's no client information in there. So there's no violation of Rule 1.6. There's no violation of anything else because, again, it's a general question. And so if it stores it, learns from it, it's not going to implicate a client file. And so I've seen use cases like that where if you can't afford to purchase the closed circuit ones, the ones that, you can do client work in, you can use these public facing ones for more general stuff. I've also heard some of my law students say that they were tasked over the summer with drafting a set of interrogatories for a certain case. They didn't know where to start. So you want to know what those students did? They went straight to an AI and said, draft me a set of, for this type of case, whether it be a personal injury or medical malpractice. They didn't put personal information. They didn't put client information. They didn't do anything that would implicate the rules of professional conduct. They just generically said, do this. And then they took that starting point and created a more precise, detailed form, which is kind of when I talk to lawyers about this. I always say use Gen AI in any use as your starting point, but not your ending point. Meaning, do it for something generic. As any good lawyer, we've got to make edits. We've got to go through different drafts and versions, add in those details that are pertinent, do that offline, off the Gen AI if you don't have one that meets the rules, and then you're fine using it. And so as long as you double check, as long as you have that oversight, then it can really help you with that starting point in your practice, especially if you're a young lawyer. So a lot of uses do come from those things. It's the uses where we don't double check the work, where we rely blindly on the cases it gives us to our detriment. And so it's those cases where we want to stay away from, where we can't protect the client information, where we're not double checking. But general use cases, do a generic, that starting point, that starting out. And then it can help you immensely get your forms together, get your generic stuff together to use in your practice.
Legal teams are struggling to manage resources, maintain compliance, and adopt new technologies. BDO's legal operations team can help. We enhance efficiency, reduce costs, and support compliance so you can run your legal department like a business. Schedule a meeting with us today at bdo.com.
One of the biggest ethical concerns with any public-facing Gen AI, and I say public-facing, I mean your firm hasn't purchased a closed circuit or an enterprise version that just, doesn't store the information. But most Gen AI models self-train and they store your information and then can pass it out to third parties. So one of the biggest ethical concerns is Rule 1.6 confidentiality. We have to maintain the confidence of our client, no matter the source, anything pertaining to that representation. So I get a lot of pushback saying, well, I only uploaded a public document in there. There's no exception for public documents under Rule 1.6. Anything pertaining to the representation, no matter the source, we have to keep confidential for our client. Meaning, even if it's on the docket, even if it's a public record, we cannot upload it into these Gen AIs if it's not going to keep the client confidences. And so just understanding that is the biggest thing where lawyers are going to get in trouble is that 1.6. And how do you know if a Gen AI model self-learns, stores it, gives it out to third parties? You have to read those wonderful terms and conditions. And so you have to go there and see what it does with this data, see how it stores it, processes it. Otherwise, you're not going to know and you're going to run into the rule. So that's one of the biggest rule violations is that 1.6. The other biggest rule violation is 1.4, communication with our clients. I can't tell you how many times a lawyer's like, well, I want to use it. I'm like, great, you can use it. Go get consent from your client. And they're like, well, I don't want to do that. I don't want to go tell the client I'm going to use it. I was like, well, that's, part of our duties, especially if there's going to be a risk of violation of Rule 1.6. Let's get that consent from the client that they know the risk, that they're going to consume those risks, and that they're going to allow you to use it. But I think there's this stigma that lawyers think if they go to the client and say, I want to use Gen AI, that the client's not going to think they're competent to do the case themselves, or there's going to be some pushback there from the client, which there rightfully might be. But the ABA Formal Opinion 512 that came down regarding all the ethical rules said that we have to have that communication with the client under Rule 1.4. And in there, we have to have a disclosure of which AI tool we're using, the risk and benefits associated with it, how we're going to use the tool, why it's important for the client's case or how it can improve the client's case, and then get the client to give informed consent confirmed in writing. So you need to put all that into a disclosure based on, what the ABA has told us. And a lot of attorneys think that's a lot. My client's not going to sign that. I can't send that communication. Well, they need to. And so that is something too, another big ethical violation that can come is just failure to get that consent. And I also will say too, I deal with a lot of outside counsel guidelines, those terms from the client to the firm. And a lot of companies and corporations are putting in their terms and conditions that they don't want their lawyers to use Gen AI, or they can only use Gen AI if they get that consent, which the ABA told us we had to get anyway. So clients are even catching on, knowing that lawyers are thinking about using these things and preemptively putting it in their own terms and conditions to force us to get that consent and comply. Now, there's other ethical violations like 1.5 fees. How do we charge for it? Obviously, you can only charge for the time you actually spent, not the time you would have spent on something. So it can really cut down that billable hour. It can also produce biased results, false results. Those can implicate rules 8.4, our truth rules like 3.3, 3.4, 7.1. All of those can come under the truthfulness as well. And so there's tons of implications, but the biggest two are those rules 1.6 and 1.4. And that's where a lot of lawyers break down. And then two, I think the third one, if you had to name one, is the truthfulness. When you get those hallucinations, those false results, blindly turn them into the court without checking them, you're lying to the court and you're lying to opposing counsel. So that's kind of where a lot of lawyers are starting to get disciplined or in trouble or sanctioned for in those areas.
This was music to my ears, and I'm hoping, obviously, Professor, to all of our listeners as well. There was something that you said earlier that I do really want to touch on again. I even highlighted it here in my notepad, and you said, read the terms and conditions. And that's really important because everything that you just said about 1.6, about 1.4, about 1.5, et cetera, none of that is even remotely possible to understand if they don't understand the fact that they've got an ethical responsibility to understand the risks and benefits of relevant technology, being Rule 1.1, obviously, Comment 8 that was amended in 2012. And I believe now 40 different states have all caught on to Comment 8 and amended it in some form or fashion. And so when you go through this whole list here, there's a couple of things that pop out to me, because one of the things that I think about is this 1.4 that you were talking about, this communication disclosure. I remember that there was an ethics opinion in California. I want to say it was about in 2010, if I'm not mistaken. And it was basically admonishing lawyers that walked into, let's say, an overly priced coffee shop. We'll just generically call it that. And they want to go ahead and use their free Wi-Fi.
Okay.
And they want to use the free Wi-Fi. And there doesn't have to be any sort of VPN or any sort of firewalls in place. And so said lawyer is working on client information on their laptop in this overly priced coffee shop, gets up, goes, gets a refill of the coffee, doesn't have a screen lock, right? And so the question becomes like, what were the ethical violations? Well, number one, they were using free Wi-Fi. Well, what's the problem with free Wi-Fi? Well, if they're using free Wi-Fi and there's no protections, they may potentially violate Rule 1.6, which then pierces the attorney-client privilege doctrine. And of course, obviously walking away without locking the screen. So now it almost seems silly to me that as an attorney, I have to ask my client if it's acceptable to sit inside an overly priced coffee shop with free Wi-Fi where there's no protection and work on their data, right? It just seems ridiculous. And so California being California, like they were actually ahead of their times there, right? They were ahead of the time because that makes sense. So now we're talking about Gen AI. So it's like, dear client, I want to use Gen AI to help me write the briefs. Well, then the question becomes is what of 1.5? Right? And so just for all of our listeners, to recap, 1.5 talking about fees, and you can only charge for the actual time spent, not for everything else. But I got to tell you, like that is something that is really a big topic. It's a big concern because you said it yourself, the billable hour. So is it possible, this is a lot of talking here, is it possible that we're getting to a point where we can actually get to a value-based billing system? As opposed to just an hourly based billing system, because Gen AI is sort of forcing this on us now. What do you think?
I think it is. And a lot of law firms, especially your bigger firms, I think are looking at that. The value pricing, they have pricing analysts, pricing managers, like whole legal ops pricing departments, and a lot of bigger firms trying to figure out how do we have that value, how do we go to more flat fee? Do we go to like a split hybrid type of situation? And the courts really haven't come down with anything because this is so new. There's been no full ethics opinion on 1.5 with the use of technology and Gen AI. It was actually my students, I was a moot court coach this last spring for some students doing moot court. And the question for moot court, one of the 3 issues that they had to argue was, how do they bill for the use of Gen AI? Is it an expense or is it a fee? And the case was cited with using Illinois jurisdiction, and there's no guidance. Like they had, formal opinion 512, they had all these different things. And so firms are grappling with, do we do it more like legal research? Is that where it's going to fall under, where even a lot of clients won't pay for legal research, or they'll only pay up to so many hours? Do we do it like we have a subscription to these AI platforms, so we prorate that subscription kind of like, a fee? But again, a lot of clients won't pay for that. They look at it as overhead. Or do we go to a different model saying, yes, we'll work on your case, but now we're not going to charge hourly anymore. We're going to charge a flat fee or a value-based fee or, something else. And so firms are grappling with that. And a lot of, like I said, the bigger firms that I've heard of do have pricing analysts and pricing managers and people trying to figure out how to merge, this, allowing our lawyers to use it, but not lose that revenue that we're used to having come in from doing the client work. And so it is going to be an interesting thing, but I can see a shift in how lawyers charge coming in the future if this keeps moving at the trajectory it's going, because otherwise all your hourly lawyers are going to have a lot of free time. So but for your contingency fee-based lawyers, this is like a dream. This is, this allows them to do more work and more volume work, at a faster rate and still get, the value they want. And then that contingency fee, instead of 5 cents on the hour, after a 5-year case, you're maybe making $5 on the hour. Who knows? So it depends on where you're at. But yes, I can see a shift coming in how firms and clients and attorneys negotiate those fees and what the pricing structures could be in the future for a lot of firms. I would like to see some updated guidance, and maybe it's the rule 1.1 that Daniel mentioned too, competence. We drop another note or comment in there just about the technology, because there's not one rule either on social media. There's not a rule on using those things, and there's not even a lot of comments. It just says we have to stay up to date on the relevant technology that affects our clients and our practice, kind of a paraphrase comment of that rule. And so even when social media and the internet and all that stuff came about, and even email was part of it too. We used to have to ask consent to send emails. If you remember way back when, if you're that old or can remember that part back then. But I do think eventually we need some revamping of at least those comments, or maybe add another section to like that competency, or add, a subpart to another rule, maybe the truthfulness rule or the confidentiality rule, or just something along there. Because with social media, the internet, and now Gen AI, the rules need to kind of come up to date with some of those things. They came up to date when cannabis became legal in state level, but still illegal in federal. A lot of states amended their rule 1.2D or dropped a comment about it. So I would like to see that happen, hopefully eventually, with Gen AI and with, even just social media, because social media is not going away either. We have TikTok lawyers out there. So it's it keeps coming. If you have not looked up TikTok lawyers, I encourage you to get on the TikTok network and find those TikTok lawyers for you. But yes, I think I would like to see an update. The ABA did come down with a formal opinion, which I'm so grateful for. It's what I've been lecturing on up until that point anyway, but just to have some confirmation that, hey, we are on the right track here and thinking about this.
So the rules, though, are so slow to change, though, Carrie. Yes. I mean, we all know this. And one of the things I'm thinking about was our conversation that we had with retired Judge Paul Grimm. And I don't remember whether it was the first or the second one that Judge Grimm came on the program with us. But, one of the things, Carrie, that we talked about was the Federal Rules of Evidence 901, which is authenticating or identifying evidence. And the practical application of trying to authenticate evidence in the world of Gen AI, whether it's deep fake or we're having the Gen AI create images for us, that is a massive ethical concern. And I'll give you an example. I heard about one of our fellow geeks out there on social media was talking about utilizing Gen AI to actually fake a receipt. And so I tried it myself, and it literally rendered a receipt with the last 4 digits of my Amex, of my credit card. And I asked the Gen AI program to make the receipt look a little bit crumpled, right? And it did. And it literally had the name of the coffee shop, the address, the telephone number, what I ordered, and the last 4 digits of my credit card. And I'm looking at this and I'm thinking this in the context of Federal Rules 901. How do I actually combat this as an attorney when the whole critical issue could be a contract and you could fake that, or it was the fact that somebody claimed you and I were both plaintiff lawyers, right? And so I've got a client who's saying they've got C7, radiculopathy, right? And it had this car accident. And so I tell Gen AI to render a photo of them playing golf on the 18th hole, right? That is just the biggest ethical quandary. Well, how do you solve for that, Carrie?
It's hard to even answer that question because you've got to authenticate it somehow. But if you can't trust what you're seeing, or if you don't even have the funds to maybe hire an expert and go through the different pixels, is it off here? Is it not off here? Like really analyze it. Like that's what I see a lot of, lawyers, if they are coming up against that, they're going to have to do that. They're going to have to hire someone to say, is this a fake or is this original? Which then drives us cost of litigation, drives up the cost of, just experts we have to have and how do we authenticate evidence going into trial. But it is a huge concern. And it's not just necessarily the pictures or the receipts, but also voice and video. Like you're recording this now. You could take my voice, take it to somewhere else, make me say something else because you have a recording of my voice. Don't do it, but you know what I'm talking about. And then, put it on someone else's body or even on my body somewhere else. And so it's not just being able to, as you say, fake that receipt, but also the voice cloning and the different things. And on top of that, cybersecurity is another topic I always lecture on too, is those phishing emails are getting a lot harder to spot than they used to be way back when. So we are going to have evidence issues. We are going to have authentication issues. We're probably going to have increased experts, trying to authenticate, maybe even see a change in those rules that we have to have those experts now, or that in order to authenticate a photo, now you have to have XYZ instead of just the person who took it or allegedly took it at that point. So you are going to have a lot of those issues coming across. And I know IP lawyers are having a field day because, as you know, AI doesn't recognize IP, such as trademarks, copyrights, or anything like that. And so then people are getting their intellectual property stolen. And then they're saying, no, it's mine, but you technically can't claim something as your own or get a patent or trademark on it if a AI model produced it for you. That is something that our IP lawyers have said and something they're litigating and different things. But again, you're going to have all these issues that are going to create more legal issues. And so I do think the rules of evidence, authentication, the rules of ethics, all these are going to have to come up to par with what's actually happening because it's not going away. We have a job for a while. I personally don't necessarily educate the clients. I educate our lawyers to educate the clients and push out that guidance in that way. But I'm always happy. I have gone in-house to a couple companies over the past few years and talked about AI. I've talked about AI with accountants. There's an accounting organization that had me come in and do a CLE for them. And, so outside the industry, like a company had me come in. Then I did it for 2 other entities. And so, yes, I think educating clients and companies is great and it needs to be done because it affects them too. And sometimes it affects their policies internally. Like, what is their confidentiality policy if they're not lawyers? What are these things? How should they advise their own employees, not just how they interact with their lawyers, but also, too, how do they manage their day-to-day? And so, like I said, a lot of the guidance right now I give is from me to our lawyers, and our lawyers should educate the clients on the stuff that affects their legal work, what we're doing legally for the clients. But I have gone in, as I said, to companies to educate them on what maybe they should be doing for their day-to-day, not necessarily with their lawyers, but their own policies within those certain companies. And I think that's part of it too. And that's why I think we're seeing the uptick in outside counsel guidelines that say no Gen AI, or you need to get approval. Here's how you do it, because they're getting smarter. They're understanding how it affects their business and their company as well.
Something else you mentioned earlier before that I think is important for our listeners as well is talking about bias. What did you mean when you were talking about bias in Gen AI?
Well, this is a fun one because, okay, so Gen AI, most platforms like your ChatGPTs, your Claudes, your Perplexities, I always describe it as they pull information from like a swimming pool. And so just imagine an imaginary swimming pool. Well, that imaginary swimming pool usually is the internet or different sources from the internet. And when you think about the internet, do you think the internet is unbiased? Hopefully the answer is no. Hopefully everyone's kind of chuckling at that. We have right wing, left wing, biased content, false content. And these platforms, these Gen AI platforms, are pulling from that pool of information that's not accurate, that's biased or potentially biased, or one side versus the other. And Gen AI is only as good as the programmer who programs it and where they get their data from and their information from. So it is going to pull biased results. It is going to pull those false results. And under the rules of professional conduct, it's 8.4D as in dog or 8.4G as in girl that are going to be implicated. I say both rules. One is prejudicial to the administration of justice, 8.4D. 8.4G as in girl is what I call the anti-discrimination and anti-bias rule, but it's not in every jurisdiction. And so if you don't have the 8.4G, they're going to get you under 8.4D. 8.4G has protected classes, just like Title VII does. It says you cannot discriminate, hold bias, or prejudice while practicing law against any of those protected classes. So if you get information that's biased or shows that bias, you're going to have a violation of not one, but both of those rules if you have them in your jurisdiction. And so that's what I mean by saying that Gen AI can produce biased results. It's from where it pulls the information, how it relays that information to you, and it can be through an image or, certain data subpoints, but it only pulls from a tiny swimming pool and not the bigger swimming pool that it should pull from. So then you have a biased subsection. So you've got to be careful too in reading those user terms and conditions. Where is it pulling its information from? Is it up to date? Is it not up to date? And how is it programmed? Those are all questions that we need to be asking too. Otherwise, you can get into those bias violations under 8.4. We test out products before we push them out to the whole firm. And so that's kind of one of the questions that, could be on our testing is, does it keep our security? Does it do this? What type of results does it produce? Are they false? Are they biased? And, getting that feedback when it comes in of how it's doing it. But no, I think it's a great thing to do because they all do it. And I was actually too, which wasn't mentioned in my bio, on the task force for Indiana, which was created and appointed last year by the legislature. We were kind of like a half-year task force talking about how Gen AI is going to be used for the state of Indiana. And just hearing some of the people who spoke at that task force, some of the issues were discussed. Bias was a big one, especially if they're going to use it in, say, jails or in criminal proceedings or in lineups. And I know that's outside the legal profession, but it's affecting everything, just if it is producing these biased results and producing these things coming back. And there's ethical implications there too, because bias is an ethical concern. And so whether it be in the law, legally under our rules for lawyers, or whether it be in a business, it's still going to be a concern at that point.
It makes me think of this whole topic of bias, just to close the loop on this one. It sounds like everything both flawed and beautiful about technology begins with the inherent fallibilities of humankind. Mm-hmm. So leave us on a good note here. So on a positive note, Carrie, so if all of our listeners out there are also struggling, which they probably are, with what to do with Gen AI, what would you recommend as a clear, concise direction as to what an AI roadmap could potentially look like for them at their respective companies?
Sure. I say don't be scared of it, first of all. It is coming. It's coming fast, and we have to learn it. So don't be scared of it. Create that free account. Get that trial period. Always think of it as that starting point, not the ending point. and just test it out. Try stuff to see where you know the answer or should know the answer so you can verify the results and test it out. But also to know that if you test it out, you think, oh, this is great and wonderful, never fully rely on it. Again, never get out of that mindset. This is a starting point, not the ending point. And it can help you, but it can also really hurt you. And so if we keep that mindset, knowing that we still have to have the oversight, we still have to check the results, and that we still have to personally critically think and give that end result and that oversight we need, then we should be able to use it safely. And also too, as much as we hate it, read those user terms and conditions before you even start. I always poll my audience and say, who reads their cell phone user terms and conditions? No one raises their hand. Or who reads your email user terms and conditions? Because Gmail has user terms and conditions. No one raises their hand. But we need to read the Gen AI user terms and conditions. Whether you're a solo practitioner in a big law firm, someone needs to be reading them to know if you can meet those compliance standards. And even if you're outside the legal industry, you still need to read them so you know if your company is going to be implicated in some way, or you're going to break a company policy or not have confidentiality in your company's information. So I guess the key takeaway, if you just want a short phrase, starting point, not an ending point, and just embrace it and have fun with it.
Thank you very much. It was a pleasure having you on the program.
Thank you very much.
Thanks for joining us on BDO's Legal Tech Talk podcast.
If you're enjoying our podcast, don't forget to rate, review, and subscribe for more episodes.
On BDO.com, you'll find all of our episodes, transcripts, and ways to continue the conversation.
Until next time, this has been another episode of BDO's Legal Tech Talk.